Hello, my name is Brian DiPaolo, and I am the Director of Strategic Services at Accudata. Started this morning. We'll just a couple of housekeeping items. First, we will have a live Q&A session at the conclusion of today's webinar. Please feel free to ask your questions in the chat window in your browser. After the webinar, each attendee will receive a post-webinar email with our recorded webinar and a copy of today's presentation. Your hosts today are Accudata Systems and ForcePoint. Headquartered in Houston, Texas, Accudata is a leader in IT consulting, cybersecurity, and system integration. For over 35 years, we've helped organizations solve their toughest IT challenge based on three core pillars: secure, modernize, and grow. Accudata has successfully partnered with ForcePoint for over 10 years. ForcePoint is a global leader in the cybersecurity solutions with a unique approach focused on understanding human behavior and the intent to protect employees, business data, and intellectual property. So at this time, I'd like to introduce our speaker, Paul Kendall. Paul is an advisory services principal in our risk and compliance practice at Accudata Systems, providing high-level consulting services to our customers in IT security, regulatory compliance, and information security management. Paul has over 40 years experience in healthcare, financial services, and manufacturing fields. During his career, Paul has successfully built information security programs from the ground up for both Fortune 500 and global companies, as well as managed existing programs in the United States, the United Kingdom, and France. So Paul, thanks for joining us today. Without further delay, I'm going to turn it over to Paul to get started.
Oh, thank you very much, Brian. Unfortunately, we're running a fairly short presentation today. This is going to really kind of preclude an in-depth dive into this topic. It's probably just as well we could spend untold hours wading through this stuff and all the details and opinions that make up GDPR. Suffice it to say, everyone probably agrees GDPR is a complex set of regulations to wade through, and there are many potential paths to compliance. Based on our prior engagement work with GDPR, however, Accudata has developed a 7-step process to assist companies in attaining GDPR compliance. This process groups functional components into major phases, allowing for somewhat faster consolidation of information and creating an integrated approach to compliance. This approach does allow us to maximize our organizational and technical expertise to best assist the client achieving their GDPR compliance goals. As Brian mentioned, we have partnered with ForcePoint many times in the past, over the past 10 years, and we use several of its products to assist clients in managing many aspects of their IT environment. ForcePoint's DLP and other solutions can be very valuable tools in helping companies attain and maintain GDPR compliance, as we'll discuss during the course of this presentation. I think most people would agree that GDPR is really a global game changer in terms of its impact on privacy of individuals. You look at a Forbes magazine article that was published on December 28th of 2017, they state point blank, the EU General Data Protection Regulation is set to affect thousands of organizations worldwide. In fact, GDPR is the most important change in data privacy regulation in the past 20 years. Before we dive in, let's look at a few of the terms that we'll be using in the presentation. Most of these will be somewhat familiar to people who are already familiar with GDPR. Data subject, that would be the individual person who can be identified directly or indirectly by particular reference to any identifier associated with them: name, address, social security number, etc. Supervisory authority is an independent public authority established by an EU member state and charged with overall management and enforcement of GDPR regulations within that state. Data controller is an organization or individual who determines what the purposes and processing means of individuals' personal data will be. They essentially, quote, control, unquote, data. Data processor would be any organization who processes personal data on behalf of the controller, but does not have control over how the data is collected or used. Today is T-minus 29 days for GDPR compliance enforcement. set to start on May 25th. Regulation actually went into effect on April 27, 2016, but full enforcement has been delayed 2 years to allow companies to become compliant. I think most everyone knows about the two-tiered fine structure. That's received a lot of press. Briefly recap, 2% of gross annual revenue or 10 million euros, up to 4% or 20 million euros, depending upon the severity of the infraction. We've had several U.S. companies ask us, well, okay, how's the EU going to enforce this against us if we just don't want to pay the fines? As with many other things, the EU regulators are going to rely on international law to issue fines. There hasn't yet been any kind of EU or U.S. negotiated civil enforcement mechanisms for GDPR, but there is still the application of international law, and EU and U.S. law enforcement agencies do have an outstanding record of cooperation between them. Additionally, under GDPR, individuals may bring judicial redress against companies, and the potential for huge legal entanglements there can occur. I think everybody would agree that in a local or a global market, reputational damage in these cases would be highly likely. So what do? Well, some people may think panic comes to mind. It's probably not your best strategy, though. Since that's not an option, we'll spend the next few slides discussing some of the critical steps you should take to meet GDPR compliance. One of the first things you really need to do is make sure you understand the requirements, starting with the accountability principle in GDPR, which states simply, the controller shall be responsible for and must demonstrate compliance with the data protection principles. This means both organizational and technical compliance aspects of GDPR. In order to best accomplish this, the very next step should probably be some sort of awareness and training for your staff. Since GDPR presents a new paradigm for data protection, it's really important that everybody in the organization be on the same page with their understanding of what's involved. This is particularly true for executive management, who must be aware of their roles and responsibilities with regard to GDPR compliance, and had better be prepared to lead by example to ensure there is a uniform approach to compliance as we move forward through this process. Your organization may have to appoint a data protection officer or a lead to work with the implementation and continued compliance. DPO may or may not be required. It kind of depends upon the nature of the processing. If your company handles HR data, or if your processing operations involve some large-scale, regular, and systematic monitoring of data subjects, think Facebook or Google in this case, DPO role is probably going to be mandatory. In addition, each EU country may also specify when a DPO is required. Germany is already up to their game by saying any company with 10 or more employees who processes personal data must have a data protection officer. It's a good idea to bring someone on board, even in a contractual capacity, to oversee GDPR compliance implementation. This is one of the services that Accudata does offer with regard to GDPR, is that we can provide contractual DPO services on a full-time or part-time basis to assist clients in moving forward with GDPR compliance. Finally, you should have some sort of governance structure in place to ensure that the appropriate engagement with the right people at each stage of the program is put in place to speed the process of compliance. Without this accountability and responsibility driving this process, it's going to be difficult to get there in a timely manner. Perhaps one of the most complex aspects of this is determining what you have. So start by performing an information audit, mapping your data throughout the organization. Excuse me. This is probably one of the singularly most important and difficult tasks to accomplish. If you don't know what you have, you can't report on it to the data subject, and you can't protect it appropriately. Mapping the data and how it flows through the organization is really a critical first step to understanding how to protect your data, and more importantly, how to fulfill those data subject access requests. You should create a record of all processing activities. Article 30 of GDPR requires that certain organizations maintain records of their processing activities. This is a mandatory requirement for organizations with more than 250 employees, and in some cases for those with less than 250 employees. Keeping a record of the processing activities documents the purposes for processing, describes the categories of personal data involved, details the disclosures and transfers of data, and notes any time limits for erasing personal data that may exist. The goal of all this is to create and maintain a processing activities register of all activities involving personal data that must be managed under GDPR. You may wish or should perform a data protection impact assessment, or a DPIA. This really involves creating a systematic description of the processing operations and the purposes for the processing, and marrying that with an assessment of the necessity and proportionality of the processing, in other words, only the data that's required, what the risks to data subjects are, and what measures you're taking to address those risks, both technology-wise and organizationally. Now, once you've got the data defined and you understand its flow through the organization, a review of your current technologies in place to protect data, both from a hardware, software, application standpoint, is performed to define the current protection environment and establish the baseline for understanding where gaps in compliance exist. In this regard, Accudata systems can provide assistance with a gap assessment engagement to identify your data locations, assist you with data mapping and inventory, and review your data protection processes, including identification and documentation of gaps that may exist, along with a recommended and prioritized process for remediation. In addition, ForcePoint's data loss prevention program can help you identify personally identifiable information throughout your environment. It works across both structured and unstructured data formats and includes personal data contained within images even. Its policy library uses a combination of content, context, and lexical analysis to identify PII. And DLP can also be used to manage and control personal data flows, helping you protect your personally identifiable information from loss or abuse. Next really important step to take is to establish what your legal use for this data is. GDPR identifies 6 major areas that are the legal basis for processing. I think most everybody's heard about the consent basis, which is basically where the data subject must give explicit consent for the processing and for the specific purposes. There's also contractual consent, which involves the performance of a contract to which either the data subject is a party to or is prior to entering into a contract with a third party. There are legal obligations the controller may have. The legal obligation legal use basis affects compliance with any kind of legal obligations the controller may have. Vital interests of the data subject is another area. The vital interest basis may be used if you are trying to protect the vital interests of the data subject or any other individuals. There are some organizations who have to perform this as a public task. It's either something that's carried out in overall public interest, perhaps something like a census, or in the exercise of official authority that the controller has been vested with. Finally, one of the larger other areas of legal basis is what's called legitimate interests, which is where the controller has legitimate interests that must be pursued, and the use of the data subject's information is part of the performance of those interests, but it is subject to some limitations regarding the rights of individuals and their data. Once you've determined what your legal basis for processing is, you should probably review your existing privacy notices. You are required to have a privacy notice in place which provides GDPR information disclosures, including your data protection officer and processes for data rights, data subjects' rights. Privacy policy should also appear on your website or other area for public visibility. There are some changes to the way that you can create a privacy notice. It cannot be buried in your end-user license agreement or other document. really must be a standalone document that cannot be written in, quote, legalese, unquote. It must be in plain language. It must allow the data subject to explicitly opt in, either by checking a box or some other affirmative indication of consent. There is no more default opt-in that can be used. Data subjects must positively affirm consent in these documents. You should have some data protection policies developed that manage the protection of the individual's data. These must really demonstrate technical and organizational measures that you're taking to comply with GDPR. On the technical side, in particular, compliance with ISO 27001 is an excellent recommendation for dealing with technical measures for GDPR compliance. It's important to understand what the rights of the data subjects are, and they are many. First and foremost, they have the right to retain or request from the user a list of all the personal information about them that's being processed. This has been around since the old Data Protection Act, but was retained and enhanced in GDPR. They have the right to know all of the data that you have, which is why that data flow analysis and mapping is so important. Data subjects have the right to request correction of any data you have about them that is incorrect. And you as a controller are obligated to make those corrections if it's at all possible. Data subjects have the right to what is called condition-based erasure. This is more commonly known as the right to be forgotten, unquote. They have the right to obtain from the controller eraser of personal data in some instances, particularly if the data is no longer necessary for the purposes it was collected or processed for, or if the data subject withdraws consent, or if the data must be erased for compliance with a legal obligation. The right to be forgotten is not an absolute right. Controllers should thoroughly understand this right to understand the associated limitations. Article 17 of the GDPR does provide a good in-depth description of the rights and limitations associated with the right to be forgotten. Data portability. This is the right to receive personal data from a controller in a structured, machine-readable format, a CSV file, a TXT file, an XML file, and to transmit that data to another controller when required. A good example of this that we see every day is if you change cell phone providers, you can generally get your data transferred from cell phone provider A to cell phone provider B. They have the right to request the restriction of data processing. An example of this may be where you have consent from the data subject to perform A, B, and C processing of their data. Well, now you want to perform X, Y, and Z. You go back and get consent for that. The data subject can say, no, I only consent to processing for A, B, and C. The right to object to processing. Now, this is especially when such processing deals with things like direct marketing. And to a limited extent in some other activities. Article 21 of GDPR does go into these in great more detail. If you're a controller, you probably, or you may have to manage data transfers and third parties or subcontractors. The EU has set aside an EU zone where data transfers may be permitted. However, if you do any kind of international transfers, it's important to make sure that those transfers are approved by the EU, that all the GDPR regulations are being followed prior to the transfer taking place. It is important to note here that EU member states can further specify conditions and additional strict restrictions for such transfer. So in addition to GDPR, you may also have to look at each member state's individual requirements for these. Any kind of third parties or subcontractors that you're using obviously must be governed by some sort of contractual or legal agreement. Subcontractors are going to have to follow GDPR requirements as well. Validating your security measures. This would include both the technical and organizational measures as defined in Articles 24 and 32 of GDPR. Basically says you're going to implement the appropriate technical and organizational measures to ensure security appropriate to the risk and to demonstrate that processing is performed in accordance with GDPR. You start by creating some information security policies. They cover the organizational and the technical aspects of compliance. Here, the use of ISO 27001 to achieve compliance is really recommended due to its general acceptance as a global standard. However, NIST standards may also be used to define your overall security program. You must have a formal data retention and erasure policy in place, along with any kind of mandatory retention requirements. The period for which personal data can be stored must be limited to a strict minimum. Now, this is also subject to any other legal requirements you have, whether they are things like SEC requirements, state requirements, federal requirements, etc. HR data generally requires a 7-year retention period. This may be changed. For example, under German law, there is a 10-year waiting period. So one of our clients has actually defaulted to a 10-year waiting period to apply consistency across all of their retention requirements. You should document all of your internal procedures and make sure that they are validated against the activities that you're performing. This should also meet the principles of data protection by design and default. Internal procedures are used in part to validate against the processes to ensure compliance with GDPR. Finally, one of the biggest ones that's caught a lot of attention from people is this concept of data protection by design and default. This must be an overriding part of all your system and process designs. Companies are definitely encouraged to implement some technical and organizational measures in the earliest stages of the design in such a way that safeguards privacy and data protection right from the start. This is the data protection by design aspect. Companies must also ensure that personal data is processed with the highest privacy protection so that by default, personal data is not made accessible to an indefinite number of persons. This may potentially require modification of your SDLC processes, such as Agile, to fully incorporate the concepts of protection by design and default. Is to have an incident response and data breach management program. The incident response program should cover all aspects of incident response, preparation, detection, response, right down through lessons learned. All incidents should be documented, particularly those that deal with personal data. In the event of a breach, controllers should definitely document any personal data breaches and make sure that they have formal breach procedures in place. If you're a processor, you must notify the controller immediately of any personal data breaches. Controllers must notify their supervisory authority within 72 hours of any breach discovery. Now, these are fairly short time windows, so having a formal process in place is invaluable to minimizing the response time and ensuring that you can meet the 72 hours limitation. With regard to these, Accudata has had extensive experience in developing incident response programs for a variety of companies, ranging from single organizations to multi-departmental, multi-divisional companies. Over the years, we've developed a comprehensive approach to incident response from preparation through recovery and lessons learned. In addition, Accudata can work closely with your company's legal department to ensure breach reporting processes that we develop align with the regulatory and compliance reporting processes required for your organization. This does include ensuring that state, federal, industry, or international requirements for breach reporting are identified and including in this process. In addition, ForcePoint's data loss prevention program can also play a part in incident response, particularly in the detection, response, and recovery stages. Their user entity behavior analytics provides behavioral analytics across the broader information environment, enhances the context around the data to support the investigation procedures. In addition, ForcePoint Insider Threat provides behavioral analytics across all user and local machine activity. It provides much deeper forensics content and can include video playback of desktop screenshots to speed up any investigation process. So real quick recap over the 7 steps. First and foremost, understand the requirements. Got to get executive buy-in and corporate understanding of these requirements as well. Determine what you have. If you don't know what you have, you can't protect it or report on it. Establish legal use basis. Pretty important that you select the correct legal basis for processing and that you follow all the recommended guidelines associated with those. Understand data subjects' rights. Pay close attention to them. There are several, and they do have some limitations in some cases. Manage any data transfers or the use of third parties or subcontractors. Not all countries are GDPR friendly, and your subcontractors should be following the same rules of the game that you are. Make sure you validated your security measures. Sound security practices obviously are key to compliance. Consider ISO 27001 or even NIST as your baseline for developing your security practices going forward. Develop your incident response and breach management processes. Remember that all personal data incidents must be logged, and in the case of a suspected or the high likelihood of a data breach, you have 72 hours to report to the supervisory authority. So kind of in summary, if you've got any questions and if you have any concerns, you're probably not alone in this, or you need any assistance at any point along this path to compliance, feel free to contact your Accudata account manager and ask to speak with one of our solution architects or a GDPR consultant about how we can assist with these or other aspects of GDPR or ISO 27001 or NIST compliance. At this point, I'm going to turn this back over to Brian, who will kind of lead the rest of this discussion. Brian?
Thank you, Paul. At this time, we'll begin the Q&A session. We really only have a few minutes, so we're going to see if we can get a question or two in before we end. So I'll start off. I'll jump right in and ask the first question. So Paul, what would you say? Defining the data in your system is the most important step to being successful? And kind of looking at the steps that appear to be in line with step 2, I believe. But what's your thoughts on its importance to the process?
In general, first of all, make sure you understand all of the content of GDPR. But this is a data-driven requirement, or regulation rather, and making sure that you understand what all the data is that you have. Do you actually need all that data to do the processing that you're doing? And how are you collecting it is absolutely critical, because these are the areas where you can really incur fines and some significant issues for failure to report or failure to obtain consent or failure to determine what your legal basis is. So from an activity standpoint, definitely data management is the most important thing you can do.
Thanks, Paul. I'm going to try to squeeze in one more question so we don't run out of time. How about this one? What is my company's responsibility for service providers who handle GDPR data on my behalf? And the example that I, when I was looking at this question, I'm assuming the example would be like I would have my HR department uses something like an ADP or something like that, where that data is then stored in their systems and it has EU employee data.
Okay. Well, if we're talking about HR data, of course, the EU GDPR does consider HR data as special data. And so any company that you use as a third-party processor is going to have to be sure that they're providing the same level of caution and care with that data as you would be required to. You are ultimately responsible for it, and making sure that they are following the same rules of the game that you are is going to be incredibly important. So you would want definitely to look at them and determine if they are GDPR compliant as well.
Well, thank you, Paul. At this time, I'm gonna go ahead and wrap up the Q&A session. What we'll do is any other unanswered questions, we can reach out to you afterwards with some of those answers. But I want to thank you for joining us today, and you will receive an email with a link to with a link following today's webinar with the recording as well as a copy of the presentation. Where you're still looking for guidance around GDPR or require assistance developing your IT security strategy, please reach out to our certified experts at Accudata. We're an industry leader in security with a 92% customer retention over the last 5 years with across our customers, and we'd be happy to start with a complimentary consultation. My email will actually be included as part of the resources after the presentation, so feel free to email me directly with any questions or requests. But thanks again for your time, and have a great day.